2 months now. Understand that I did receive an email from a reporter last week asking for an update because we did promise that we'll meet the mayor Monday, even though the ban was for 6 months. We meet the mayor Monday to have a conversation to see how the ban was going to continue. So based on that, we have a meeting scheduled with the mayor for Friday afternoon. I'm here today to give you an update on where we stand. I'll hand it over to the president of the division, Brother Louis Tucker.
Yes, good afternoon. I'm here for Bermuda Tucker, president of the Poor Workers Division. We are here today to try to bring clarity to the public and all the stakeholders in the shipping industry as far as the work on overbearing has been implemented. We would like to keep in mind that according to the information that the public has received thus far, we are here to give you a little more clarity. Right? The main characters aren't, according to popular belief, Brother Chris or the wrongfully terminated staff member of Steel Road Services, and he's also a member of the BIU Union. We are here to focus on the main character, which is the CBA agreement between SSL and the Poor Workers Division. The importance of this agreement is that we collectively agree on it, first and foremost, and we adhere to what is actually in that agreement. For example, Article 30 is one of the most important articles as it pertains to the situation we are in today. We would like to get the public support, management and SSL team to recognize Article 30, which is reinstatement rights. With us recognizing that collectively, we can come to a resolution or common ground as to how to deal with this situation we are facing today. Realistically, if this agreement was adhered to from the beginning of this 5-year span, we would not be here today talking about reinstatement. It would have been a simple addressing all the process and procedures are to be addressed, and we would have an answer and a resolution long ago. All right. So, if Brother Chris would like to get anything,
Sure. Certainly, I think that as the president of the division just said, is that when you look at this, the agreement between Steel Road Services and the Poor Workers Division of the BIU, we can go all the way back to 1970 and 1971. When you look at the article reinstatement rights in that collective bargaining way back in that year, you will notice that there's been one minor change in the very next agreement after 1970 to 1973. We actually made a change to the reinstatement rights article to strengthen it between making sure management here can have a conversation about the need to bring that worker back in the workplace. So if you go from that time frame of 1972 to 1973, let's say 1970, that's 53 years ago. So 53 years ago this year, this agreement has been in place. So the article has remained unchanged for 53 years, unchanged. My understanding is that you have recently concluded some negotiations for 2024 to 2027. Each side have an opportunity to bring any changes to the collective bargaining agreement. Whether you want to change reinstatement rights, you want to change management rights, you want to change union rights, that was the other opportunity to change any article you want to change. I can tell you that article in the current agreement to 2024-2027 remains unchanged. So as the president just said to you a few moments ago, it's kind of interesting having this conversation because our situation that's respectfully goes all the way back to 2020, where we had a worker that was dismissed from the housing docks and that's done, and we just declared my interest. It was my son, Christopher Jr., who was dismissed on February 6, 2020. Understanding the reason why he was dismissed, he was dismissed for threat. Threat. Supposed threat against the CEO. Mr. Jones, who was the CEO at that point in time, I don't want to get into names, but I certainly have to identify Mr. Jones as the CEO who launched a criminal complaint about that threat. All I can tell you is fast forward to talk to June of 2020. The prosecution said, oh, sorry, Mr. Jones, this will meet the criteria for legal threat, so that's going to fall away. I would have thought at that point in time, the parties would have got back to the table to find out exactly what went on between Mr. Frederick Jr. and Mr. Jones on the day in question so we can get some clarity. That never happened, and because it never happened, then the Minister of Labor tried to refer the matter to arbitration. Stevedoring Services for several years has said this was not a labor dispute. The public has to be aware. The reason why this matter took 4 years and a half to get settled, because it weren't settled until September of 2024, Stevedoring Services delayed the process. They told the labor relations officer, if the matter is referred to arbitration, the employer will ask for judicial review, and in that judicial review, they're going to seek is to say this is not a labor dispute. They had that, the judge ruled against it. They said they're going to appeal the judge's decision because the judge added law, so they appealed to the appeals court, and they lost that decision. 2 court cases they lost. And then, of course, we had the arbitration in 2024, and the tribunal rules that the employee was unfairly dismissed, but they didn't order reinstatement. So we believe, as a union, they're out of law. The workers have decided that because the number has 2 court cases, and also one is arbitration, they want the CBA to be upheld. If the article says that if the employee is unfairly, unjustified dismissed, he should be reinstated with all his back pay and his benefits. So, as Brother Tucker said just now, it's the President Division. All they're trying to do now is make sure the management team uphold this collective bargaining agreement. Any questions?
Yeah, well, thank you, sir. I guess the one for me is what's the next step if management disagrees, if they don't go ahead with it?
Well, management have not agreed because you know that the overtime has been in place for 2 months now. You know, cameras back up a bit. I understand now the cleared quite a bit on, but certainly the workers took the decision to support their member, and I have to be crystal clear so the media understands, because people say, "Oh, that's his son. He's talking about his son." Let's just be clear. It's my son, but it's also a member of the BIU. Has he had any preferential treatment? No, he has not. This is the first time a case has gone this far as an employer saying, you know what, we can't agree to this, minister. First time that the union's been put through something like this. And if you think about a process, fair treatment, to make sure everybody is treated fair. We know that if you look at, those of us who look at social media, there's a group of workers, could be 5, might have been 6 of them, who had a little press statement or press conference that said that, we don't want him back down here, and he'll on y'all. First of all, that is not your goal. If a member is found to be unfairly dismissed, you can't decide whether you want him back or you don't want him back. That's not your goal. That's my job. So you're telling me I work on the dock for 20 years, and 5 people or 7 people can decide that I can't have my job back? I think the public has to understand that if this was any other worker, other than Chris Frederick Jr., would the decision still be the same on the Hamilton docks? I can tell you this, that if this was any other area, let's speak outside the docks now. If you were in government, you said telco, or we said another company that we have organized, and our member were 1, 2, 4 cases and 1 arbitration, I can tell you the members will probably be down in tools, but I'm member to be reinstated because they want the CBA to be upheld. Why is that can't be the case? If anyone else, that'll be personal. That's it. That's the only answer.
You made reference to a meeting that was happening on Friday. I didn't catch too much of that.
I'll let the president speak to that.
Yeah, please.
Yes, so we're having an update meeting. We've had 2 so far, and we've agreed to do that. Friday will be the 3rd meeting we're having to update the members on the overtime ban, and there will be a vote being taken place whether we will continue with the ban or lift the ban and go back to work. Let me be clear that whilst the ban has had an effect on the public at large and also all stakeholders in the shipping industry, keep in mind also that the poor workers are also people of the public. So everything that is being spread around the island as far as the shelves in the stores and retailers are looking a little light, we shop at these stores as well. So the pressures that the public is feeling, we understand 100%. But this is not something that we intend on putting the public through. This is our early voice and our early card that we can play when it comes to industrial action. And that is suspension of overtime. And we are always looking out for the public's best interest. We don't want to go through this. So we try to minimize the impact by a slight ban in overtime to get the attention of the employer. So with that being said, we've come to you today to let you understand that the employer is still not listening to us. So our only other option is to get the voice of the public to support us in getting the employer to come to the table so that we can get a resolution, so that we can go back to regular business and the smooth operation that we provide for this country. We've been rewarded, not even rewarded, awarded things overseas that the public probably isn't aware of that are based on our performance in the Caribbean. We've reached milestones. So our work ethic is always in the best interest of the public. And I think we have been executing that well. So what are we asking today is that the public support us because we have you in mind and we also support you on behalf of the Poor Workers Division. And as we go back and we want to take back during the times of the COVID, we were out there. I mean, we never really shut down when it comes to providing our service because we know how important our work is to the public. So with that in mind, we have your best interests in mind, and we continue to do that today and into the future. But right now, all we're asking for is a little support and the public's voice to ask the employer to come to the table and make this process that they started off incorrectly. Let's make it right. Because the process, procedures, and steps have been agreed on, like Brother Chris said, for the last 50 years. So if there was any discrepancy that needed to be adjusted and looked at, they had 50 years to look at it. And we've just signed off the 2024 to 2027 collective bargaining agreement between the Poor Workers Division of the BIU Union and SSL Management, and they saw no problems with Article 30. Because if there was a discrepancy of Article 30, they would have requested to make some adjustments. So they were fine with this article. So let's follow this article collectively and bring a resolution to this matter.
Before I ask any further questions, I do understand both sides, Chris Herbert Jr. and SSL, are appealing the decision of the Employment Tribunal with regard to the dismissal in February 2020. Is that correct?
Well, I can tell you that is correct. And basically because, let me just clarify this issue of the employer is appealing the amount that the tribunal has awarded because they believe that Mr. Chris Herbert Jr. has been awarded too much. So just to clarify for the public, Mr. Herbert has not received one dime from the award, not one dime. In relation to the BIU is appealing based on our law because if our member was found to be unjustified dismissed, then why was he not reinstated? And that's why the workers are saying that, first of all, don't try to get in the middle of the courts, but the CBA is saying he was wrongfully terminated. He won 2 court cases. He should have his job back.
So if yes, why not wait for the results of the appeal before taking industrial action? See if you can turn things around in the courts.
Yeah, but if you appreciate that this has been 5 years, right? If you go to when this first happened in 2020, understanding that the management team, and because I get the information, I can share with my members. When Mr. Jones dismissed Chris Ferber Jr. on February 6, 2020, he wanted to make sure that there was no kind of industrial action. So he put a memo together and told his staff, and I think it's dated February 10th, if there's any kind of sick house, blah, 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 just know you'll be deducted up. And he didn't take that as any threat to the workers. But here's what Mr. Jones said in the fact finding during arbitration. And I'm on quote, because I don't want anybody to think I'm making this stuff up. This was directly from Mr. Jones, okay? Directly from Stephen Oil Services, and rely to the statement of facts from Stephen Oil Services. Mr. Jones informed them, this is Mr. Jones having a meeting at 2 p.m. on Friday afternoon, the day after he fired Chris Ferber Jr. Mr. Jones informed them that the first claimant had threatened him and reiterated the words the first claimant had used. Listen to the last sentence. The comment of one member was that they could not support that, and they left Mr. Jones' office. And the one member that said that to Mr. Jones was an officer of the division. How do you listen to a manager, say what he needs to say, don't give it back to your member, confirm exactly what they want, but agree with the manager, That was a big issue.
Are you quoting the tribunal?
I'm actually quoting what was said by Stephen Oil Services. This is what they said.
In the tribunal.
In the statement of facts back to the tribunal.
Okay.
That's what I just read.
So obviously the tribunal details are all public.
Absolutely.
Public and
Absolutely. You got it.
I just want to go back to that. So
You got it.
the tribunal ruled that Mr. Ferber Jr. was unfairly dismissed because SSL did not follow the grievance procedure as set out in the CBA.
That's correct.
However, the tribunal also appears to accept that there had been threatening behaviour on the part of Mr. Ferber Jr. and did not order his reinstatement.
What was this trying to be?
It's in the document. The ruling has gone before the courts. You're appealing that ruling, but it's come out of the courts. So all the evidence that you just spoke of, all the quotes, have gone before the courts, and this is the decision they made.
Not because
The tribunal also considered the CBA in its final award ruling and reduced the possible financial award based on, quote, the complainant contributing to his dismissal, end quote. So ultimately, do you accept one part of the ruling of the employment tribunal that Mr. Ferber was unfairly dismissed, but not the other, that he should be reinstated? Is there a degree of cherry picking here?
First of all, if you say that he was unfairly dismissed, let's think about what you just said. Somewhere in the ruling, you're going to see that, taking your point, the tribunal felt that he contributed to his dismissal by raising concerns and needs, because that's what they said. He appeared to be very vocal in his staff meetings. Well, first of all, if I'm a staff member and you have a staff meeting and I have concerns and I'm raising, how am I now telling you, or how's the tribunal now saying, actually, you shouldn't be talking in that meeting. Because you were talking in that meeting now, I can't give you your job back. Because that's exactly what they said. Because if you also look at the ruling, they compare Mr. Ferber's conduct or the Stephen Oil Services decision or their decision to some kind of drunken person. That's on page, whatever page it is, and whatever numbers on. That's also in there.
So here's the question. We're having a discussion in a press conference.
Yes.
But this went before an employment tribunal,
Yes.
set by Ed Baldwin,
Yes,
I believe.
that's correct.
So essentially, are you saying the tribunal's got it wrong?
I think we're saying the tribunal erred in law by not giving him his job back.
They've erred
In law by not giving him. First of all, if you find him to be unfairly dismissed, if you say he contribute to 25% of the dismissal, we can have that conversation. But if he only contributed 1%, and let's just say because they approached Mr. Jones, they had a little conversation, should that have been a warning? Should that have been a suspension? I don't know, but it should have been a termination.
But clearly the tribunal does not agree with you.
But the tribunal agrees a lot with a lot of what I'm saying.
So why don't you wait to see if you can win this in the courts and say, and turn the tribunal on that decision?
Yeah, but so if you think about that, so understanding they're making an appeal, does it happen this year? Does it happen next year? Understanding that the workers want, I guess, the courts to understand, and they want the public to understand, they just want the CBA up. Meaning that if my number was wrongfully terminated, then the ultimate thing after that is my job back. That's due process, meaning that I was unfairly dismissed. And if it says that, I think the agreement is clear as far as what the parties should be doing. The parties should be, particularly the union and the employees, should be coming together, having a conversation about what that looks like. And I think that's the point that Mr. Tucker has made. We're gonna see that against that 53 years, and this is language in there. But the employers, they don't want all the language in there.
Is there a risk, however, that this situation may compromise future CBA discussions? Why will employers look to engage with unions over such matters when a tribunal can make a ruling, but the union is not accepting them?
But neither is the employer.
The
The employer is not accepting it. Remember now, they're appealing also. We're both appealing. The employer is appealing and the union is appealing.
And you already spoke to the main issue being Article 30 reinstatement.
Yes.
So when you say come to the table, essentially you mean that with a proviso. Come to the table willing to reinstate, or else there's no coming to the table.
No. Coming to the table, as I stated in a previous report that I did with you not too long ago, the meaning of coming to the table is let's come to the table and have a conversation about how this was handled incorrectly. There's no secret that it was handled incorrectly. It started wrong, right? It started wrong, right? It was addressed incorrectly. So we want to come to the table where we always solve industrial action or disputes. According to history, there's always a meeting point. We have to get out of this idea of trying to delay, and appeal, because that is looking like the absolute strategy that is being used there.
You just referred to our interview, and in that interview, you said that they tried to come to the table previously, but the SSL will not shift on reinstatement. So if SSL is not shifting on reinstatement, you're not shifting on reinstatement, the table looks a long way away from.
No. I don't recall those being my words, shifting and all that. All I was doing was requesting on behalf of the Poor Workers Division that the SSL, which is the employer, come to the table. We have JCC meetings that are happening once a month. We haven't had a JCC meeting for the last, how many months? A number of months. And this is a standard that the public isn't aware of, that we have JCC meetings. All those meetings were postponed due to the fact that we have an overtime ban. So we have understood that the overtime ban is preventing us to go to the table. And they've made it very clear. We've communicated back and forth, and they've expressed to us, as long as this overtime ban is in place, we will not be having any meetings. And we will not be allowing you to have any meetings on the docks inside of the working hours. So that leaves us early lunch hour or after 4:30 to have very important meetings. And this topic right now that we are dealing with is paramount. We should find any opportunity to go to the table and discuss this matter.
So will you meet on a lunchtime if SSL?
If they agree to meet with us, we will meet at any time around the clock, because this thing is impacting the entire island, and we need to bring a solution.
Just to, you referred about looking for the public support. Do you believe you have the public support? Do you think the public is on your side in this?
This is what I know. We do not have 100% because that's almost impossible to achieve, but we have a very large percent of understanding, especially those that work in the labor industry. They understand the importance of a CBA. Now, I can't speak for those who don't work in that environment, in an organized union environment, but when it comes to the CBA, people that understand it and live by it and know what it provides in keeping them gainfully employed and being fairly treated in the work environment, those are the people who support that we have. And if we let this thing slide by the wayside, that's just a small piece that our forefathers fought for, sacrificed for, marched for, protested for, and negotiated. We can't just let that go by the wayside because that opens the door for other employers to not recognize other things that are in CBA agreements.
My final question is, you spoke, Mr. Herbert, about seeing this as personal, possibly against yourself, against your son, but what about the other way of it being personal? What do you say to those who suggest the reason this is happening is because it concerns your son, the son of BIU President Chris Herbert?
So I'm glad you asked that question because remember now, as the president of BIU and as Chris Herbert is your father, as his father, here's what I'm going to deal with, and here's what the public don't. Several years ago, while my son was working on the dock, he receives a threat from one of his co-workers. You know what the threat is? And the threat was like 3 feet apart because they were standing on a machine together. I'm going to get my son to shoot you. That was reported to management, and they done absolutely nothing about it. Nothing. So when you talk about this criminal complaint, that within itself, had the management team follow the employee handbook and follow what they did follow, that employee should have been been brought up on charge.
Is that on record?
I
Is
can
there a
tell
record of a complaint?
what I can say to you is that that complaint was given to the management team about,
And when was this?
well, what, 6 years ago, 7 years ago? Before Mr. Herbert got terminated. Before he got terminated. Because he told
That's
us,
a very serious.
is it serious? Here's another one for you. We have another worker who's still there, who's trying to stab workers. Got a knife in his mouth. 2 incidents. Both of those 2 employees still working in the dock. You want to talk about conduct, serious gross misconduct? Where I'm saying to the CEO, I'm going to get you. What does that mean? Instead of him conducting a complete investigation, Mr. Frank, what do you mean by what you said? Well, first of all, the way you're treating Mr. Dance, I'm either going to get some legal advice or I'm going to get the leave because I don't like the way you're handling it. He was fired because he says, I'm going to get you. What does that mean? That's why the criminal complaint filed away. If it don't amount to a criminal complaint, that's why I filed away. What they said is they meet the test. But that's a very important thing for the public to know. So I have not interfered with this process. The lawyers have dealt with it. The workers have dealt with it. I haven't asked for the preferential treatment. God, you should bend over time because this is my son. 5 years we waited for outcomes for the courts and outcomes from the arbitration. Then we gave the workers an overall update on everything. And that's when they say, you know what? It's time for us to support them now. Any further questions?
Yeah, I mean, so if somebody threatens to shoot me, I go to police. I mean, was there any police complaint made about
No,
that?
you know, maybe Mr. Trump thought, you know what, I'll report it to management, see how it dealt with or whatever have you. But certainly the other one was witnessed by management. Because management was sitting right there. The stabbing part, the stab workers, the management was sitting right there. So they heard it. First time.
These are all things that there should be police complaints. So if the employers themselves, your union members themselves, are not making those complaints, this situation can't be corrected.
Your point is well taken. But what about the management team? Because my understanding is that when people are fighting in the dock, and the police come to the Hamilton docks and say, we need to get some stories, and everybody says, well, I'm not talking. So that has to go. I agree with you. I should make my own complaint. But if I'm also working for an employer, where's my protection whether it's under the employee handbook, whether it's under CBA. Where's my protections under that too? Where's that too?
Where was in these incidents? Where was the union involvement? Because if you turn to the management and they're not doing anything, don't you automatically turn to your brothers in the union?
Mr. Skelton, I agree with you. My concern is that, first of all, you can't raise this issue about, okay, that was a criminal complaint from Mr. Jones or Mr. Fabric or Mr. Jones. But a real criminal complaint is shooting somebody. A real criminal complaint is trying to stab somebody, because that's grievous bodily harm. And they're struck on the carpet by management. I think the stabbing incident, I think the brother got 1 day suspension. Did he go for that? I think he got 1 day. I think he got 1 day. I may be wrong, but I think he got at least 1 day suspension.
So I guess the last one from me, and I'm not trying to draw this out anymore, but if they just refuse to reinstate the worker, are you contemplating something with further industrial action than the overtime ban?
No, remember now, the dock workers are in essential service. They have to give notice of 21 days of industrial action according to the law. Yeah. And then, the minister could step in on the 19th day or 20th day or probably the 21st day. The prime minister's got a deadline and say, you know what, the matter is referred to arbitration. That's the process.
Gotcha. Last one from me. So you made reference to a JCC meeting. I don't know what the JCC meeting is. What's it stand for?
Joint Council.
Joint Consultative Committee.
And you haven't been able to have this meeting?
No, not since the overtime. I would just like to add that to Father Chris' point. A lot of incidents have been happening, and there are things in place that is also in the agreement, the CBA, that the best way to deal with it is internally first. Whether it's misconduct, insubordination, bullying, preferential treatment, anything like that falls under the CBA, and we address it internally. That's why these instances weren't put out into the public or called for the assistance of the police service. Because the first step that has been agreed on between the employer and still between the employer and the co-worker is that we deal with it internally. So that way we have a proper paper trail and record. So if it does become an issue where it needs to be dealt with in the judicial system, then we have paperwork, a history, we have a statement. Right? So for the most part, we do handle a lot of things internally. But what we have been going through since the overtime ban as board workers, and my fellow workers can definitely attest to it, is that we have been victim to decrease of wages, pay cut for persons that are in support of the overtime ban. They've been mistreated or unjustly treated, preferential treatment. So, for instance, if you're on board with assistant management with not adhering or abiding by the CBA, and you're working outside of the CBA, you will allow preferential treatment. We've witnessed that. We've witnessed side meetings with persons of management, with our union members, to get them to work against the brothers and sisters that are standing in solidarity for the overtime ban. Right? So we have to endure all these things outside of the eyes of the public in the sake of keeping this operation running. So this is why we're saying we have to be very strategic, if you can understand what I'm saying. And reason is, if we step out of line and do anything outside of what the CBA asks us to do, there's a thing called an injunction. So all our sacrifices of overtime and what we're standing for to get this whole situation resolved, goes away the minute we do one thing wrong outside of this CBA. And that's the little tricky little card that the employer has that they can just hang out there and just wait for us to do anything out of character. For instance, dawn and chills. That would be the worst thing for us to do right now. I know some people in the public I've heard say, well, why don't you guys just dawn and chills? You can't do that. You have to be strategic for this to have the maximum impact. So we've gotten to this point where we are still not being heard by the employer. And like I said before, we are asking the public to support us so that we can get the employer to come to the table, as I already requested a few weeks ago, so that we can get a result. Because it was clearly started wrong, and we need to make it right.
I think just going clear, I'd just like to make a plea because I know that only so much will be in the newspaper tomorrow, only so much will be on the news this evening. So I guess from Bermuda's point of view, if you want to, I guess show the whole transcript of today's. You got when you told us the whole thing. Thank you, appreciate it. Thank you.
Thank you. Let me just, if I
Yeah, sure. Yes, yeah.